I have an interesting topic for you today, and that's the alibi defense. And so, what is the alibi defense? We often hear that term, well, I've got an alibi. And first of all, the word alibi is a Latin term which means elsewhere. In the criminal law context, and specifically Canadian criminal law context, it means I have evidence that I was elsewhere at the time of the crime. So in other words, I could not have committed the crime because I was not there when it was committed. So there's a lot of rules about how we present an alibi defense in Canada. So first of all, the first thing to know is that if you're an accused and you do have an alibi and you got some solid evidence of alibi, you need to disclose it to your lawyer right away. What are the rules around that? Well, what I do, and I've had the opportunity to present the alibi defense several times in my career, successfully I might add. And what I do is this. I usually hire a private investigator to investigate the alibi very carefully. That's so important. You want to, like, for example, the person says, there's a window of opportunity to commit a break and enter, for example, or a murder, whatever it is, serious crime. And the client presents me, look, I was at a bar at such and such a time. I have this witness, an ex-witness. I was using my cell phone at the other end of the city. So you'll want to hire a private investigator to get bar surveillance, interview those witnesses, get the GPS coordinates from the cell phone and put that all together. So as a lawyer, what I'll do then is after I'm completely satisfied, you've got to be satisfied because it can backfire. If it's not a solid alibi, it can completely backfire. I'll explain why. So once you know that the alibi is true and accurate, there's an obligation on you as a defense lawyer to present that alibi to the Crown sufficiently in advance of the trial so that the police have an opportunity to fully investigate it. If you don't do that, and this is a mistake that some rookie lawyers have made, they just bring up an alibi at the trial, the judge, if it comes to the judge's attention that you didn't disclose it to the police sufficiently in advance of the trial to allow them to investigate, the judge can basically put a very low credence on the alibi, can almost just basically ignore it if they want. It's kind of discretionary, but an alibi where you don't give the chance of the police a chance to investigate is going to be discounted completely by a judge, if not fully 100%. So that's what we do. I will, rather than giving a statement from the client, though, I don't want to give a statement. I outline in great detail the exact nature of the alibi. I have this surveillance, I have this video, here's the surveillance tower research, the GPS coordinates, who's using the phone. Obviously the break and enter occurred between 1 and 3. He was elsewhere at the time. If it's a solid alibi, sometimes the Crown will just withdraw the charge. Maybe they'll come up with another theory about their timeline, of course, on the break and enter or murder, and that does happen, of course. So let's assume that we then go to trial with this. Well, as a defense counsel, you're going to want to then cross-examine the Crown's case bit by bit, disclose the alibi with whatever surveillance you have, and try and show that the client was elsewhere at the time of the Crown. Pin down the timeline, and he couldn't have done it. He wasn't there. So in a break and enter case that I had a few years back, the Crown had this theory about the timeline, and it was the only timeline for the break and enter because the homeowners were there before it. My client couldn't have done it. They had a circumstantial case against my client. I didn't think it was that strong, and I was surprised the Crown, frankly, didn't withdraw the charge, but ultimately we won the case. Now, the burden of proof on the Crown, if there's an alibi, the Crown has to prove beyond a reasonable doubt the absence of an alibi. In other words, that the alibi doesn't apply. There's no reasonable doubt that the client's lying, essentially. Not to a mathematical certainty, but they have to prove beyond a reasonable doubt that the alibi does not apply. And then they'll look at their circumstantial case or their direct case after that to see if they can prove the case beyond a reasonable doubt. Now, the problem, if a lawyer presents an alibi that's got serious weaknesses and it's totally exposed or even minorly exposed at trial as being a lie and made up, which can happen easily if you don't investigate it, maybe your client's lying to you. The problem with that is the judge can use that as consciousness of guilt that you lied to try and get yourself out of this situation and use it as evidence of guilt against you, coupled with the other evidence in the trial. So in other words, defense counsel have to be very careful. You have to understand exactly when to disclose it. You don't want to disclose it too early for various reasons. I don't disclose it until I'm sure, until I've investigated, and then sufficiently in advance of the trial, which may be months before the trial, to allow them to fully investigate it. And if you don't know that law as a lawyer, you need to learn it, and you need to disclose this to your lawyer at the earliest possible opportunity, so they can preserve evidence, because there might be text messages that need preserving, GPS coordinates, whatever. There's surveillance, like bar video might be overwritten in 30 days. The lawyer's got to get it on right away. So there's a little bit of a simplified primer on alibi evidence. I was elsewhere at the time of the crime and I should be found not guilty, and the way a lawyer has to present that both to the Crown and then present it in court to try and create a reasonable doubt that you did not commit the crime. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.